Hey everyone, Harry here to talk about what's going on with the 14th Amendment Section 3 provision that seems to suggest that maybe Trump isn't eligible to be president no matter what. All right, remember, this is really a kind of tricky and slippery constitutional issue. The section, which is part of the very important 14th Amendment passed in the wake of the Civil War, the same one that gives us due process and equal protection of law as against the states, says that if you're somebody who swore an oath to the Constitution and then helped out with an insurrection, you can't serve anymore in federal office. So different groups are pushing on that to say Trump isn't qualified to be on the ballot. It is accepted that that provision states a quote unquote qualification for a presidential candidate, same as being native born, same as being 35 years old. So in theory, if, it's the same as bringing forward a birth certificate that shows that a candidate is 34 years old or will be at the time of taking office. So what would happen then? In a presidential race, it's a little tricky, but we assume that a state court could say, hey, Secretary of State of our state, we find that this guy is not qualified to be on the ballot, take him off the ballot. And that's what people are trying to do in Colorado. And that's what people are trying to do in Minnesota. Now, in Minnesota, it's sort of served up as a clean legal issue before the Minnesota Supreme Court. And there were arguments this week where the court, you could see, was really skittish and saying, why us here? Are we really the right people to make the declaration that Donald Trump is not qualified? And the people on the other side were saying, yeah, you're exactly the right people, at least for Minnesota. Once you make it, the issue may have to proceed and with real speed to the U.S. Supreme Court, but this is what would start it out. But the Chief Justice of the Minnesota Supreme Court was saying, this feels like a political question to me. It feels like something Congress has to weigh in on, and I don't know. So my read of the tea leaves in Minnesota is they're going to say something like that is just not for us to do. That, and here's the big second point, kind of brings up the history here. So this was passed after the Civil War, obviously, by members of Congress, the then Republicans who didn't want the then Democrats because they had made, they'd been traitors against the Union to just saunter back into Congress. And it was first enforced, but then they said, okay, enough, we're not going to do this anymore, and sort of passed a general amnesty. But it's still been used, including in the 20th century, as against a socialist candidate in World War I, whom Congress as a whole said had committed insurrection by not supporting the war effort, and actually booted him under this provision. So there is some, authority for it. And moreover, we have a whole very respected conservative to liberal set of opinions, scholars, the former judge Michael Ludig and others saying, this is what the Constitution says. And let's assume it is, well, first, on this is what the Constitution says, at least in Colorado. So back to Colorado. I've told you about Minnesota. In Colorado, they're having a trial, and they're asking the court to determine as a factual matter, did Trump swear an allegiance? I think so, when he, took the presidential oath. And did he then engage in insurrection? So one of the things it's bringing up is, hey, what's an insurrection? And, what is the definition of that under the Constitution? And there's a war of expert opinion. And the Trump forces are saying this is too vague. But the forces saying take them off the ballot are saying, no, if you basically use force to try to impede the government, that's insurrection. Query whether their definition is sort of too broad. But anyway, so this trial is now going on in Colorado. Let's say Colorado, so we have the substance of the provision. stands to reason that somebody somewhere will actually say, I think it applies. Trump, you're off the ballot. Then what happens? That'll be when the real action is, because even the strong proponents who say the 14th Amendment, Section 3, is quote unquote self-executing, by which they mean you don't have to have anything else happen. You don't have to have a trial or an act of Congress. It just is what it is, and it's sitting right there. Even those folks say this is going to have to go to the U.S. Supreme Court. So let's say the first question, is there time? For example, in Colorado, they've got to make final ballot decisions, I think, by January. So if they hold that that Trump is not on the ballot, there's got to be a kind of a race to the Supreme Court to decide this issue, or at the least, it's going to be a big old mess. But let's say that some court or other holds that just as these very eminent scholars and professors, including very conservative professors, are saying, it is what it says it is. Trump did engage in aiding and abetting insurrection anyway, and that's enough. So a court holds it. Now that will quickly, I think, go up the chain in a particular state, and from there to the U.S. Supreme Court on the federal question. Basically, what does this provision mean? And more importantly, this is where the action's going to be. So you should focus on this as the issue progresses. Who gets to decide? Because you can well imagine that the Supreme Court of the United States says, look, it's not like we can just make a fact finding. We don't do that anyway, that Trump, engaged in insurrection. It's necessarily a political question for Congress, say, so we can't weigh in. Or maybe they say, if there's a trial and he's found guilty, that would do it. But that would suggest, a single state somewhere could hold it and somehow he's kicked from the whole ballot. Or the court could say, no, it's ultimately a question of federal law, and it's a constitution we're expounding. This is to us, and here is what insurrection means, and actually even apply it to Trump. And here's why it's legitimate. For my money, notwithstanding the strength of the arguments from the scholars and the like, that it seems to apply as a predictive matter, I find it hard to suppose that the Supreme Court is just, at least 5 members of this Supreme Court are just going to take it on themselves to say, here's what insurrection means. Here's what Donald Trump did. He's on the ballot or he's not on the ballot. I think you will rather see courts kind of leaning way backwards to say, this isn't for us to say. But of course, even if they tell us for whom is to say, like, say, Congress, that at least advances the ball. Or maybe they just say, we can't speak to this, and that's all we're saying for now. Let the issue percolate. So we're left in a really funny position here. This is an important provision of the federal Constitution and a very elementary and important amendment. It's got to mean something. It sure seems to mean that if Trump helped with insurrection, that he's done. A little asterisk. Other argument he's making is he's not an officer of the United States. Everybody is till you get up to president. I think that's a loser, but I just wanted to let you know that's another claim he's making. And we may find ourselves in one of these very frustrating constitutional positions where the court says, it sort of did this in gerrymandering. Yeah, there's a constitutional violation out there, maybe, but we're not going to speak to it, and there's no way to go forward on it. Something seems very wrong in that case, especially this is such an important provision. It actually, there's a whole clause in the Constitution that says a president serves 4 years. And if you just flagrantly violate that, can help in an insurrection? Is there really no practical way to bring to the fore the 14th Amendment command that says you're out, pal? That, though, is what the issue is going to be. There's both, so to summarize, where it's right now in Colorado and Minnesota. Some court somewhere is going to find that the clause applies. Otherwise, it's all a moot point and an academic debate. At that point, it's going to have to move quickly to the U.S. Supreme Court. And once it does, I'm here to say what will matter more than the meaning of the provisions is the court's determination of who gets to decide in the constitutional system under the separation of powers and federalism that define our governmental structure. And moreover, that they may opine on that matter to basically say nothing to be done, which would be very frustrating, but in character, perhaps, for what this court has done in other important constitutional realms. So keep an eye on that and wait for everything to get triggered by a decision. And then we're in the race to the U.S. Supreme Court to see what they will say. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.